right. And so in reading violation of condition number 15, I think the name in that violation is incorrect.
It is, Your Honor. And I discussed that with the.
And are you Brittany Brown?
Yes, ma'am.
Are you the same Brittany Brown who was placed on deferred adjudication in 2023 CR 0042 for the offense of assault bodily injury married on February 6, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
And did you review that motion with your attorney?
Yes.
All right, state.
Your Honor, on or about the 6th day of May 2024 in Bear County, Texas, the defendant, Brittany Merrill Brown, did then and there fail to follow all TAP treatment recommendations as directed by the court and or Barrett County Community Supervision Department in violation of condition number 15.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bear County Jail? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, Your Honor.
Court will find violation of condition number 15 true. Is there a proposed agreement?
There is not, Your Honor.
All right, state, what are you requesting?
The state is requesting an extension of community supervision for 2 years and an amendment for DDRF as recommended by TAP.
All right, this is a misdemeanor case.
Your Honor,
So,
may I say something?
you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, yes, what would you like to say?
Well, I was gonna go to the SATA program and they told me, they came and saw me and they were like, get off their medication and you can go to our program. So I got off the medication and then they still denied me. And like, I've been here since January, away from my kids. Like, I was just hoping I could have another chance to do outpatient. I'm hoping for another chance, Your Honor. I'm begging for another chance.
Okay,
That's all I have to say.
all right, this is what we're gonna do. We're gonna come back at 2:30 and I'll give you my decision at that time, okay?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
All right, we're gonna go back on the record in 2023 CR 0042, Brittany Brown. And where we left off, Ms. Brown, you had told me some issues you were having. All right. I'm not a medical doctor, but before you go off of medication, it may be best for you to contact your doctor to see if that's something you should be doing. You understand?
Yes.
All right. So on this one, she was placed on probation in 2023. I'm not going to extend her. So probation, you all are recommending on Ms. Brown, you all are recommending SATF?
Judge, the recommendations for DDRF.
All right, DDRF. All right, and has she already been approved? There's no other,
Your Honor, I believe there was a similar issue with when she got off her medication to go to SATF. And then the SATF didn't accept her after that. And then I think, at least according to my client, there was an issue with DDRF not accepting her because she had gone off of her medication. So I think there was an issue on.
all right,
both sides.
so Ms. Brown, are you currently on your medications?
No, and I haven't been able to get back on them since SATA told me to get off of them so I can go to the program. And I got off of them and they just still denied me. And then I still haven't been able to get on meds. They haven't gave them back to me. And I've been off since April.
All right, so here's my question. The medication you've received, who was that through?
It was through here.
All right, so probation. Can we make sure that the jail knows that she's supposed to be on medication? So that,
So it looks like the eval is for MIC supervision only,
okay,
not for inpatient.
all right. So state. That was Mr. Dunn. My understanding is the state wanted to continue her.
Yes, they were asking to continue and extend for 2 years as well as DDRF. And we were asking, we weren't opposed to the continuation or to the extension, Your Honor. We were just asking for outpatient treatment, given the circumstances with the difficulty getting into DDRF and for SATF.
All right, and so in reading violation of condition number 15, I think the name in that violation is incorrect.
It is, Your Honor. And I discussed that with the CLO at least the main one. She was aware of that issue. Both violations that are alleged are still for Ms. Brown. I think there was just a typo in the name.
All right, so you have no objection to the oral amendment to the correct name and the violation of condition 15? All right, so Ms. Brown, have you ever been out of custody since you've had this charge?
Well, yeah,
All right, so have you been out of custody while you've been on probation before?
yes, Your Honor.
All right,
I
so,
just- I'm sorry,
no problem.
I just been here since January.
All right, so you were placed on probation and then you were out of custody, is that correct?
Yes,
All right, and my understanding, we had DDRF was not available because of her length of probation.
Correct. She would need at least 1 year remaining for DDRF.
Okay. All right, so who were you living with?
my mom.
And has anyone talked to her mom to see if her mom wants her back in the home?
I have not been in contact with the mother.
All right. Do you have your mother's number?
Yes.
All right, so this is what we're gonna do, because I don't want to set her up to fail. If you'll give her number to your counsel, then if you in probation can speak to her
Okay.
to see if she is okay with her going back to her home, then I'll be able to have an idea of what to do with this case.
Okay, can do that, Your Honor.
All right, thank you.
Thank you.
And probation, is drugs an issue in this case? Or I should say illegal substances?
I don't show any recent UAs, Judge.
Okay.
Probably because she had been in custody for these evaluations. The last UAs were failed to submit and a negative back in July of last year.
Okay, so what's gonna end up happening, your attorney, you're gonna give him your mother's number. And then the attorney in probation can speak with her. And if for some reason that's not an appropriate place for you to live, then we will figure out somewhere else for you to stay.
Thank you, Your Honor.
All right, thank you.
I'll make a call right now.
Probation on this case, before we go on the record, is there a place for her or something we can do if her mother decides not to let her live with her?
I can see what housing resources we've received from our reentry specialist
Okay,
and print those out for her just so she can have for her release.
all right. And then we're going to go back on the record in 2023 CR 0042, State versus Brittany Brown. So, Ms. Brown, have
Yes,
you
Your Honor.
talked to your mom on the phone? All right. Did you ask her if you could stay with her? And what did she say? All right. Here's the thing. If I go on your word and allow you to live with your mom, probation is going to call. And if your mother says you can't live there, you can't live there. All right. So I'm going to deny the motion, alter and amend conditions to include MIC, because I see where she is eligible for MIC, correct? So we'll place her on the MIC caseload. And do you have a case manager or anything of that nature with Center for Healthcare Services?
I need to get back over there on Fredericksburg to my doctor.
All right, so we're going to do a referral to Center for Healthcare Services. You're going to need to provide a release to probation. And you need to let them know who your case manager is. And you're to reside with your mother. And you're to make sure that probation has that address. Do you understand? Probation, is there anything else she needs?
The only other thing, Judge, would be if you want to order some type of outpatient component for her, the dual diagnosis outpatient.
All right, we'll do dual diagnosis outpatient. And my previous conditions will stand. And there's also to be no unsupervised contact with minors. And counsel, once she is stable on all her medications, you can always come back and change that. So for now, if you want to be around minor children, even if they're your own children, your mother or some adult that's approved by probation must be present. And that's just until you get back stabilized on your medications. You understand?
Yes, Your Honor.
Is there anything else you need from the court? All right, we can go off the record. Here's the thing. If there are issues or something's happening at your house, maybe you and your mom are not getting along. Because I tell people all the time that when you live with somebody else, if you're living in their space, their rules apply. No matter how old we are and it's our mom, if they want the television off at 10, TV must be off at 10, whether you're 12 or 30. All right?
Right.
If something happens where you all get in an argument and she say you have to leave, don't just throw your hands up. If she wants you to leave, you come back to court or call your probation officer and we'll figure something out. Don't just fall off the face of the earth and then you're back in blue. You understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
Have you excused?
Yes. All right. On Cristobal Gomez.
I think today was the deadline for plea, Judge.
Yes.
We've conferred with the state. I've conferred with my client. At this point, we do not have a meeting of the minds.
All right. So Mr. Mr. Gomez, your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plead open to the court. Do you understand?
I was gonna ask you, ma'am, if I can drop it down a little bit. I mean, I'll sign that.
No. Here's the thing.
Yeah.
And I want to tell you some rules because sometimes I know that people don't know the rules and especially the legal rules, right?
Yes, ma'am.
These are the legal rules. I am not a part of your plea negotiations with the state.
Okay.
What ends up happening is the state will tender an offer. Once they tender an offer, your attorney is ethically bound to tender that offer to you.
Mhm.
You have a choice. You can either accept it or reject it. Sometimes you can make what's called a counter offer. And what a counter offer is, if you tell your attorney, I won't accept A, but I will accept B, then your attorney is ethically bound to go to the state and say, my client will not accept A, my client will accept B. You understand?
Yeah.
But I am not a part of your plea negotiations.
But I never had an A or a B.
Oh, well, here's the thing. When I say A or B, I'm going to ask you some questions. I don't want to know what the offer was to you. Did your attorney come to you and tell you this is what the state is offering you? Yes or no?
Yes, ma'am.
All right, that's an A.
Okay, okay.
All right. Did you tell your attorney you did not want to accept what the state was offering?
Yes, ma'am.
Did you tell your attorney what you would accept from the state? No. You haven't told him what you would be willing to accept?
Well, I had to, I asked him.
No. Yes or no? Because I'm not trying. So you haven't told him that you would be willing to accept a different offer?
No, I have not.
All right.
I've conferred with the state judge. There's no wiggle room. So at this point,
All right. So what your attorney is telling the court is that the offer that you want from the state, there is no need for him to go to the state with that because the state is saying they are not going to go below whatever they offered. Do you understand?
Yes, ma'am.
So do you understand that?
Yes, ma'am.
Have you internalized it?
Yeah, no, I got you.
All right.
Thank you.
So is there anything you don't understand?
No, I understand everything.
All
now.
right.
Thank you.
So whatever the state offered you, they're saying they're not going below that. Is that correct?
yes, Judge.
All right. So then what I need to know from you is whether or not you're entering into an agreement with the state or not.
No,
All right. So you want a jury trial. That's where we are.
no, that's-
Well, I mean, if the state is not going to give you what you want, then and you're not going to accept what they're offering, then the next step is a jury trial. Okay.
Okay.
All right. How long do we all expect this trial to last?
2 to 3 days. It's not gonna be a long one.
All right, Ms. Ferguson, I need a jury trial date on Cristobal Gomez. Thank you. And she's gonna give me a date. That will be your jury trial date. Counsel, if there's an issue with his clothing exchange, just let the court know. You're going to be brought over to court for trial in whatever clothing you were arrested in. If you wish to be attired or dressed in something different, you'll need to do a clothing exchange with your attorney. If your attorney is having some sort of issue with the clothing exchange, they'll let the court know and we'll see what we can do to expedite it.
We'll get him close, Judge.
All right, thank you.
August 6th.
All right, your jury trial date is going to be August 6th.
Thank you, Judge.
All right, thank you. And counsel, have you all already done an acknowledgement of discovery?
I'm not sure. No.
All right, if you all do an acknowledgement of discovery before you leave. All right, thank you. All right, are you going to have witnesses?
Yes, Your Honor.
All right, let's call this back in the afternoon then. Norma, Jaime Torres is going to come back at 2. right, we'll bring you back at 2 with your witness.
Yes, Your Honor.
Sorry, this is Jaime Torres. Manuel Sandoval, are you all ready to proceed?
All right.
Court is calling 2023 CR 3142, State of Texas versus Manuel Sandoval. Can I have parties announced for the record for the state
Zach Dunn for the state, Your Honor.
defense?
Matthew French for Mr. Sandoval, are you ready?
And are you Manuel Sandoval?
Oh, yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Manuel Sandoval who was placed on community supervision in 2023 CR 3142 for the offense of assault family, second offense on August 29, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
State?
Your Honor, on or about the 9th day of January, two thousand and twenty-four, in Bear County, Texas, the defendant, Manuel Sandoval, did then and there fail to attend and complete Bear County CSCD's Substance Abuse Intensive Outpatient Treatment Program in violation of condition number 30.
How do you plead to that? True or not true?
True, Your Honor.
And the state will waive and abandon the other violations, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 30, the court could find it true, grant the motion, sentence you up to 6 years in the prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 30?
Yes, Your Honor.
All right. Court will find 30 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
Yes.
I think state had let it be known to council, you know, the drug use was a primary concern. Following the recommendation for amending of conditions to include SATF followed by aftercare. And I know council wants to speak on some more things, but that is the proposed recommendation.
All right. So I'm not going to follow that agreement. This is not his first motion to revoke, and I had already previously put those conditions in place, and there has been no follow through.
Well, he's not been into an inpatient treatment program, Judge. He's agreed to do that today. Judge, just a little bit of background. He was having difficulty. It's referenced in the reports to the court. He was having trouble with finances, keeping jobs. He was doing odd jobs. He's also in this time period, Judge, his father was diagnosed with prostate cancer and has been given only about 6 more months to live, which is the time is ticking on that as well. So he has some other issues that he was dealing with. He understands the situation. He's asking the court to follow that agreement. I understand the court's concerns about it, but drugs seem to be the issue for him, and he's willing to go to that inpatient treatment, Judge. He still has quite a bit of time left on probation, so the court could continue to monitor him after that drug treatment.
All right. This is what the court is going to do. The court is going to grant the motion. There's an affirmative finding of family violence. The court will sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Sands, S-A-E-N-Z, Andrade. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
So do you, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on community supervision. The court will request therapeutic community for you. Whether or not you're placed in that is not in my jurisdiction to order, but I know they will definitely not consider that for you if you do not request it. It does not increase the time that you're in custody. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
You're welcome. Who's here on Jalen Zavala? All right, so on this one, there's an issue with payment, correct?
Yes, Your Honor.
All right, is she able to pay?
No, Your Honor. So, I was appointed to represent Ms. Zavala in January of this year. She was arrested for the state jail felony offense of driving while intoxicated with a child passenger. The court did permit her to have an in-home device. However, Ms. Zavala lost her job and has been unable to secure employment. As such, she fell behind on the calibration scheduling for that in-home device.
All right, where has she looked for employment?
So, Judge, from May 29th through June 10th, she's applied at multiple different.
What places?
She was working at Amazon in January, and then she's now applied to Walmart, to a staffing agency called Balances Staffing.
All right, they're hiring at Chick-fil-A, they're hiring at McDonald's, they're hiring at Burger King, they're hiring at Whataburger.
And she's applied to Dairy Queen, Auntie Anne's, as an optical sales associate somewhere else, Snowbird, Shaved Ice. So she's made
Okay, I
an
think you
attempt
should
to-
apply, try McDonald's, Walmart, Whataburger. Is he talking to someone? Who is speaking to the inmate? Who are you speaking to? I'm sorry, who? Where is he? Yes, you're excused.
I was trying to get him this letter. Give his lawyer and trying to figure out.
Give it to the deputy and then you're excused. All right, thank you.
So Judge, she has been making those applications. I was going to see if the court would consider possibly waiving that in-home device. Ms. Zavala, while she was arrested for that DWI with child, there is an exception under 17.44B. It says a magistrate can waive an alcohol monitoring device if it's not in the best interest of justice. I guess for the court to make that decision, the court would need to know that when she was arrested for DWI, she was incredibly cooperative and compliant. She did provide a breast specimen and it came back at a 0.01 and a 0.02 respectively. So it's not alcohol that was the issue. I don't know whether drugs are on board or not. However, it is my understanding that the state has submitted the blood, which she did consent to provide a specimen of to DPS for a toxicology exam.
State, do you want to waive the in-home device or no?
17.441B, Your Honor, and it is at the discretion of the magistrate if you find that it is not in the interest of justice.
Well, I know, but are you in agreement with the waiver of it?
Yes, Your Honor.
All right. Then what are we going to do instead of that?
Well, Your Honor, she's not driving. She doesn't have a vehicle. I don't know whether there are drugs on board. The report doesn't seem to indicate that there is any sort of presence of drugs. I would say possibly maybe if you would want her to submit to a weekly UA. Transportation has been an issue because she's not driving and she's been relying on her father to get her to different appointments, and he does have a full-time job.
All right, this is what the court is going to do. The court is going to waive the condition of the in-home breathalyzer. I'm going to order no driving. So you're not allowed to drive. Do you understand?
Yes, ma'am.
And I'm going to order sober support meetings, and you can do those by Zoom. And I'm going to order 60 sober support meetings in 60 days. And there's going to be regular UAs, and I'll waive the fee. And I'm going to have them test for alcohol. And those UAs need to be once per week. All right, is there anything else? All right, thank you.
Thank you.
Thank you. You're welcome.
Can I be excused, Your Honor?
Yes. All right, the court is going to call 2022 CR 3521, State of Texas versus Armando De La Rosa. Can I have parties announced for the record for the state?
Ryan Graham for the state of Texas.
For the
Miguel
defense?
Naca for the defense.
And are you Mr. De La Rosa?
Nothing to do with me.
Yes, ma'am, I am.
All right, we're proceeding by video from Mr. De La Rosa. He's Mr. De La Rosa.
Yes,
Showing
ma'am.
what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video.
Yes, ma'am.
Defense, do you have any objections?
I already been locked up on my life.
No objections, Judge.
State any objection.
None, Judge.
Mr. De La Rosa.
And then they wanna play,
For deferred education or community supervision.
just as
Did you review that document with your attorney? Did you
get me locked
understand
up again.
it?
Yes, I have, ma'am. Yes, I have.
Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. De La Rosa, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, I have, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we do have a couple of clarifications, Judge. There's 2 counts on there. We proceed on count 1, waive count 2, and then also waive the repeat offender enhancement.
So
No
proceed on
objections,
count
Judge.
1. Waive count 2. Sorry. And waive repeater.
Yes, Judge.
Any objection?
None whatsoever, Judge.
Bogus.
All right, so Mr. De La Rosa,
Where's my?
Yes, ma'am.
so it's easy for us to hear on this end. I'm gonna ask that you mute yourself until I ask you a question. If there's something you need to say, just unmute and that way we can keep everything up. because there's some noise coming from your end.
Thank you, ma'am. Sorry about that.
No problem. Mr. De La Rosa, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am, I did. And yes, I did understand everything and did sign it in all appropriate places, ma'am.
All right, did you understand in count one, you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I do.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am, I did.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am, I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, I do.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. De La Rosa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, they haven't.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am, no one.
Are you satisfied with the way you've been represented?
Yes, ma'am, I have.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea bargain agreement, the state is proceeding on count one. Punishment is to be assessed at 10 years in prison. There's a $1,500 fine. The state opposes your application. The state will take in consideration 2022 CR 2011 and 2022 CR 2012. Did you understand that to be the plea bargain agreement?
Yes, ma'am, I did.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, have there been any such motions?
None have been filed, Your Honor.
Then to the offense in count one of the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objections, Judge.
Mr. De La Rosa, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I did, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you've applied for deferred adjudication. Ms. Ferguson, do you have a date to come back for sentencing? All right, we're going to come back on May 25th for sentencing. Mr. Nahara, do you expect to have witnesses?
It's a potential, Judge. I've talked to my client about it. I don't know for certain at this time.
All right, State, are you anticipating having any witnesses?
I don't think so, Judge. I don't think we'd have witnesses, just argument.
All right, so Mr. Nahara, we're going to set it at 9 a.m., but if it turns out you have more than one witness, let us know because it may be moved to 2 p.m.
Understood, Judge. May 29th at 9 a.m.
May
25th. I'm sorry, that was my fault.
Okay. July 25th?
According to Rebecca, they're so far behind. They're asking for everything to be set mid to end of July.
So it will be July 25th. They're telling me, Mr. Nahara, because of the
Ooh, that-
backlog.
Okay, understood, Judge. I'm sure my client would just appreciate the earliest date possible, and that's July 25th. That's what it is.
All right, so it will be July 25th at 9 a.m. And are you requesting a TAP evaluation, Mr. Nahara?
I think that would be appropriate in this case, Judge.
All right, and that will be with the TAP evaluation, Rebecca. All right, I'll send you all to a breakout room to speak with probation, and Mr. Nahara, you may go to a breakout room or you may be excused.
I'm gonna go for a little bit, Judge. May I excuse myself from there?
Yes.
Lovely flowers, Judge. Have a wonderful day.
Oh, thank you. Have a great day too. And I'm not even a mom. Well, just to my students, so. All right, the court is calling 2021 CR 8724, State of Texas versus Tavon, Washington. Can I have parties announced for the record?
Ryan Gerber for the state of Texas.
Kathy Compton for Mr. Washington.
And are you Tavon, Washington?
Yes, ma'am.
All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Washington, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
All right, it appears that the state is proceeding on the indictment as presented. Is that correct, Ms.
That's
Compton?
my understanding, yes.
Mr. Washington, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Do you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Washington, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishments be assessed at 2 years in the prison. There's a $500 fine, affirmative finding of deadly weapon, and no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Or sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
Yes, Judge. David Alford, State's Exhibit number 1.
Any objections?
No objection.
Mr. Washington, I'm showing you what's entitled waiver consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation, testimony, and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty. Are we proceeding with sentencing?
We're asking to do that, Your Honor.
Anything you wish to say on behalf of your client?
I would just ask the court to follow the plea bargain agreement.
Okay, what happened?
He probably got the worst day of his life. There was, I think it was just a lot of things that with Tavon that kind of just came to a terrible head that day. And he's very remorseful. He wants to just move on and put this behind him. He's never been in any serious trouble before now, although the conduct itself obviously was very, very serious. He has spent enough time now in jail to where I believe that he just wants to be able to move on and live his better life. And I don't think you will ever see him here again. I think that he will be finished with this and move on to be a very productive person in society. He's a very intelligent young man. I think that he just made some really poor decisions that day. And unfortunately, it's one of those things where there have to be consequences. We understand that, but I do think that that's why the state offered the minimum sentence in this case.
Okay. And how much time does he have in custody?
How much time? do you have?
11 months.
Yeah, so he's well on his way to finishing it up, Judge.
All right, then I'll send you to 2 years in the prison. There's an affirmative finding of deadly weapon, give you credit for any time served. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Washington, good luck to you.
Thank you.
All right.
Have a blessed day.
All right, you too. All right, court is calling 2021 CR 2127, State of Texas versus Hannah Marie Smith. I have parties announced for the record for the state.
Brian Brewer for the state of Texas.
For the defense.
Monica Guerrero for Ms. Smith.
All right, defense has filed a motion asking that the defendant's bond be reinstated. State, are you ready to proceed?
Yes, Judge.
Just so we're clear, some things happened. I think I remember this. Ms. Smith was not supposed to be driving. Ms. Smith, I believe, was behaving inappropriately and was asked to come to court. The court had no idea that Ms. Smith had been driving for who knows how long. And Ms. Smith drove to court, but she was in a vehicle on Zoom, and then she drove to court. So that's where we are. So Ms. Herrera.
And on that day that she came to court, apparently her retained attorney withdrew. And then I was appointed to represent her.
Yes.
So I haven't had this case very long. However, the court remanded her without bond on that day, and she's been in custody since. Her family is extremely supportive. They sold her vehicle so she wouldn't have a car anymore. Her employers contacted me, her boyfriends contacted me, civic leaders have contacted me, her mother has contacted me. They all want her to get back out so that she can go back to work and show the court what she's done. She's been in 12-step programs. She has not had any positive UAs. She tells me that, she's been doing everything that the court has asked her to do, and that she was unaware that Ms. Corley had filed an affidavit of non-driving. She had been blowing into an in-home device, and she would like very much to be placed with a bond so that her family can make her bond. That if she has a vehicle, that she will put ignition interlock in there. But as of right now, her mother has told me they have sold the vehicle and they no longer have anything for her to drive. Her bond was set at $50,000 in inception.
Well, even though Ms. Corley did an affidavit of non-driving, people in this court who are on DWI, I always let them know and have them present when someone is doing an affidavit of non-driving, because I tell everyone that they need
ignition interlock, and they say, oh, they're not driving, and I say, well, they need to provide an affidavit of non-driving. My concern is, she filed an affidavit of non-driving. Obviously, her signature is on it, because it's an affidavit of non-driving, and yet she drove to court and she didn't have ignition interlock.
Judge, if I may, obviously, Judge, I was going to bring up, my recollection of that day was the same as yours. I did want you to take judicial notice. I know you were on the Zoom that day. You know, if there is an affidavit of non-driving on file, I mean, I presume that she signed it and that, you know, she was aware that she wasn't supposed to be driving. Regarding the indictment in this case, it's a very serious charge, among the most serious charges you can get involving a vehicle. And that's why we believe it's important, Judge, to not take it lightly, the fact that she said she wasn't driving and then she was for sure driving that day that we see her on Zoom driving. We can presume that she was driving on other days if she thought she was just free to drive. The state would ask for her bond, if you grant her a bond, for it to be doubled to 100,000 along with full GPS house arrest.
I'm still trying to figure out, why should I grant her a bond when and mind you, Ms. Smith, I don't take any of the facts of these cases true, because I haven't heard any facts. But what I have is, you're charged with intoxication manslaughter. You did an affidavit saying that you would not be driving, and yet you were driving, which means you were driving without ignition interlock, and you're charged with intoxication manslaughter. The number one rule when you have any intoxication offense, if you're doing an affidavit of non-driving, you don't drive. If you're driving, you have to have you have to have ignition interlock. So I'm not going to reinstate the bond. You're remanded without bond.
I'm sorry, I forgot that I had signed the paper and wasn't driving for that long. I'm really, really sorry. I have been doing so good and I want to continue to do good.
But you knew you were driving without ignition interlock. But if you want to give testimony, I will swear you in.